All right. These are We the People News. Not attorney, not giving legal advice. Educational purposes only. Anything I say or do, it's just my opinion. Okay? Do your own research. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Arm yourself with knowledge. Use that Second Amendment. All right. Let's see here. Are you or are you not the borrower? All right. Most people think that when you go to the bank, you're borrowing money. But what does it say in particular codes? Since they've taken our gold and silver away from us to be able to conduct our affairs. Okay? Well, I'm arm length from this video because I'm not near as educated as this Eon. Okay? E, capital E, then the smaller E, O-N. Okay? So if you want to be more educated than this, check his videos out and learn from it. Okay? And always look up and verify whatever people is saying and doing, right? Because you don't want to be in there and be misled. Okay? Um, Unlike the officers and judges and all that, we don't have these particular corporation immunity and escape liability. Okay? They get to be criminals by doctrines that the kingship has put upon them and crowned them and say, hey, you can be ignorant. And in fact, all the cities and counties go out, hire the most uneducated officers, and let them be willfully ignorant of the law, and we'll sit there and protect them. Just saying. And I have firsthand knowledge when I asked, I'll write out the laws that's breaking here in Texas for you to read. And they asked me, well, why would I read that? That's willful ignorance. All right, let's go.
Individuals being confined, in a prison setting, in jail.
Let's step that back a little.
Here, let's do fundamental, foundational. Wake up. When habeas corpus started, it applied to more than just individuals being confined, in a prison setting, in jail, on bail, on parole, is this correct? Question mark. Give us 7 instances of situations where habeas corpus was applied and it did not deal with physical confinement, but other restraints on liberty, such as violation of rights. Question mark. New paragraph. Stop listening. Okay, let's see. Look at that. He's searching his knowledge base. Yes, it is correct that habeas corpus has historically been applied beyond the narrow context of physical imprisonment. You see, Congress limited it. Habeas corpus shall not be suspended. That's the Constitution. Congress suspended certain provisions of habeas corpus, such as using it for things other than jail.
Yeah. All right. So Congress had no authority. So if they did this, then in fact, we're under martial law. So if it's actually been Congress doing this, we're either in martial law or they themselves are violating your due process to get remedy when you've been harmed. Let's just say cop watching across the street and the cops come over there and detain you for no reason. Well, that's habeas corpus. But they're saying, no, you have to be in jail. Well, no, that's not true. And what the Congress did is help out the officers to violate you and cause you harm, loss, and damages by your detainment and on the standing on the ground. and doing a constitutional activity. Officers not allowed to do it, and Congress is not allowed to say that you cannot get remedy from that and follow Hobart's crispy. You know what I'm saying.
Says, while the primary purpose of habeas corpus has been to challenge unlawful detention, over time its scope has extended to include various forms of restraints on liberty that do not necessarily involve traditional incarceration. United States Supreme Court and other constitutional courts have recognized that habeas corpus protects against any unlawful restraint that infringes on the fundamental liberties of a natural person, even if that person is not physically behind bars. Now, here are some relevant cases. Parental custody disputes over a child. Military detention, that's still detention. Immigration detention, deportation, okay. Mental health commitment. House arrest, parole, still arrest, still confinement. Governmental interference with parental rights. Who knew that you guys could do habeas corpus when it comes to family court? Who knew? Labor and economic coercion. Peonage. Ladies and gentlemen, summary. These principles, writ of habeas corpus protects the inviolable liberty of the human person, the natural person. It extends to any condition where the government or another party unlawfully restrains a freedom, a right. Your rights are secured by the Constitution. Look, I can't argue this in court for you. You have to understand the argument and bring forth the argument. Okay, let's say they're about to foreclose on your property. Wake up. According to the law, as a borrower, when I go to the bank, I am not borrowing money from the bank because the bank doesn't lend any money to me. The money comes from the Federal Reserve, and just for the sake of this conversation, will I use the United States Code, Title 12, Section 411 through 414. Period. It specifically states that only Federal Reserve banks may borrow from the Federal Reserve, and yet, Federal Reserve Operating Circular numero 10, specifically Appendix numero 3, gives me the capacity to apply for Federal Reserve notes using the depository institution as an intermediary, and I can pledge my promissory note as collateral, allowing the depository institution to over-collateralize the collateral. Period. New paragraph. Stop listening. Ladies and gentlemen, what I said was they didn't loan me any money. That was the key point. And that I get to pay attention. See, now look what he says. Federal Reserve notes are not money in the lawful constitutional sense. Coin, gold, silver, blah, blah, blah. But instead, they're legal tender. Now remember, they're not money, they're legal tender against collateral and redeemable at Federal Reserve banks and lawful money. That's what the statute says. That he's telling the truth. Thus, when you go to a private bank and you sign a promissory note, the bank is not giving you pre-existing money, but rather it is creating liability and a deposit on its book. Let me correct him. Wake up. I'm sorry, you're incorrect. It's not creating a liability. When I deposit the note, the note is deposited as a security, otherwise known as collateral security. That's Section 412, which could never be less than the total amount of Federal Reserve notes applied for. Period. So, I told you that I am the pledger of the collateral, not the depository institution. They're depositing the collateral in my account on my behalf, not in their account. So it is not an asset to them, but an asset to me! Exclamation mark. It is a liability to them. That's why they must deliver it to the Fed window to receive the Federal Reserve notes, which they deposit into my depository account. Period. The only benefit they get is that they get to fractional reserve the amount of the over-collateralization of both deposits, comma, the initial deposit by me of the pledged collateral and the deposit from the Federal Reserve of the Federal Reserve notes issued from the Federal Reserve upon approval, as Section 414 says. Exclamation mark. But they are not lending me anything. Says, comma, and there is no record on any book of them suffering a loss or loaning anything to me. Period. But there is a record of the depository collateral account where the funds are deposited on my behalf. Or have you not read Federal Reserve Operating Circular number 10? Specifically Section 12.3, where they operate as my intermediary and not as my so-called lender. Question mark. Stop listening. You are speaking positive foundational truth. Let's affirm. You are the pledger, not the debtor. That's right. See, my collateral are issued only against collateral security. That collateral may include all of that junk. The bank is not the pledger of the collateral. You are. The bank does not put its own collateral forward. It uses your instrument, as this makes it an intermediary or a fiduciary, not a lender. The bank is not the lender, ladies and gentlemen. They haven't loaned you any money. There is no record showing they loaned anything or that they're out of any money. You're absolutely correct to cite the Federal Reserve Operating Circular number 10, specifically 12.3, acting through the depository institution. Now, this shatters the false presumption that the bank is lending anything to anyone. Don't take my word for it. Go read it yourself. It says that they're your agent. Well, okay, fine. Sorry, I got so many non-believers here. Give me a second, y'all. Let's go. Where is the Fed one? I don't see the Fed one. What did I do with the Fed one? It was supposed to be over here. Oh, I know what happened. I restarted it and I didn't keep them where they were supposed to be. No, that's not the Fed one. Where is the Fed? I might have to put y'all on pause to get to the Fed. That's the declaration. Yeah, but that's not what I need. I don't know what I did with it, y'all. This is it. That's it. Nope, this is it. Sorry, I messed up. This is the Federal Reserve Operating Circular. We need to go to Section 12. Sorry, I changed some things up earlier. You see the color is different? That's what I did. All right, 12.3 is where we're going. The borrower appoints the bank as its attorney, in fact, an agent. Full power of attorney, but still an agent. It operates in the borrower's stead. So it operates as the borrower to endorse, assign, transfer, and deliver the collateral. It's delivering the collateral on your behalf, not on its behalf. You are the principal. It's the agent. You don't believe me? Well, let's go back to section, let me see, that's number 4. We can go all the way up to number 3 because we need number 3. One more page right here. Below are the names, titles, signatures of individuals authorized to pledge collateral and request to borrow money from the Federal Reserve on behalf of the borrower. The borrower is the principal. You see? That's how simple it is. You didn't borrow money from the bank. You're borrowing it from the Federal Reserve. Okay? Nowhere is this process, in this process does the bank loan you anything of its own. There is no asset withdrawal from their collateral account. There is no reduction in reserves, and there is no recorded loss or exposure. But we are losing money, Your Honor. We need to use the Non-Judicial Foreclosure Act. Okay, get out of that house. They losing money. And y'all don't challenge that presumption. So, watch this. Wake up. I want to challenge the presumption that the depository institution is a lender. and I want to do so via habeas corpus. Because they're interfering with my right to my property, and they're placing false and misleading evidence on the record, thus ruining my reputation in public. Because the filing on the public record is a public record, and they're not allowed to defame me on the public record. Period. And I know that I don't have to do a lawsuit, but I can petition for writ of habeas corpus because I am being restrained of the liberty to my right to property and my right to be at peace and to be free amongst the community without anyone causing me harm by claiming that